This is Court Watch with Alex Swoyer, and I'm excited to bring you the latest episode of my podcast, where I am joined by Phelan, a Texas attorney who has worked for Baker Botts. He joined Dr. Phil's podcast recently to highlight some of the legal issues he saw during former President Trump's hush money trial in New York, where he was convicted of falsifying business records to allegedly cover up another crime. Several legal experts have told me they believe the former president has solid arguments to make on appeal. One is that the jury instructions handed down by the judge did not require the jury to identify the underlying crime that elevated the falsifying records charge into a felony. The second is that the porn actress Stormy Daniels, who is the one who was paid hush money not to go public with allegations that she had slept with the former president years ago while he was married to Melania, took the stand and testified in detail about their sexual encounter. Mr. Phelan said the former president's conviction could also be overturned on the same grounds that Harvey Weinstein's conviction was overturned. Weinstein was originally convicted of felony sex charges in 2020, but that guilty verdict was overturned by New York's top court, which said too much prejudicial evidence had been allowed in. Mr. Phelan took some of my questions about this point he made while appearing on Dr. Phil's podcast. Here's some of our call.
Yes, the cases are alike. There's a rule of evidence, it's Rule 403, that says that when the unfair prejudice of evidence substantially outweighs the probative effect, the evidence can't come in. And what the Court of Appeals said in the Weinstein case was this. Weinstein was on trial for raping 3 women. The judge allowed the prosecution to put on the testimony of 3 other women who said they were raped. The Court of Appeals said that evidence should never have come in because its unfair prejudicial impact dramatically outstripped its probative value. The judge also, in that case, did something else that happened in Trump's case, and I'll tell you what the things were in Trump's case in a minute. The judge told Weinstein that if you take the stand, I'm going to let the state cross-examine you about every complaint that has been made against you of sexual abuse. Mm-hmm. And the Court of Appeals said that too violates Rule 403, or under Rule 403, that too should never have been said. And it kept Weinstein off the stand. So for those 2 reasons, the highest court in New York reversed that judgment and remanded it for a new trial. This is not a reverse and render point. It's a reverse and remand point. Mm-hmm. The parallels to the Trump case are that the judge let in 3 things that were very similar to the testimony of the 3 women in the Weinstein case. One was Cohen's guilty plea, which had no probative value in Trump's case, but was hugely prejudicial because it allowed the prosecution unfairly to argue Cohen pled guilty to this crime of federal election law violation. Trump did it too. He's guilty too. Now, they weren't that explicit about it, but that was the thrust of what they said.
The suggestion.
Yeah, they put it in, they questioned Cohen about it, and then they argued it in closing argument. That's probably the worst of the 3. The second one was to admit the testimony. Well, let me back up. They also allowed the admission of the non-prosecution agreement between the federal government and AMI, this guy David Pecker, who had been paying hush money for Trump.
Right.
And it was, a very similar point and argument. You guys were scared of getting found guilty for violating the federal campaign laws by making these campaign contributions to hush these women up. So you entered a non-prosecution agreement. You did the same thing that Trump did when he put Cohen up to paying off Stormy and then reimbursing him. Mm-hmm. The second thing is the testimony of Pecker about paying off Karen McDougal, the Playboy centerfold.
Right, because she wasn't even part of the records keeping infraction, right?
She was really close to the other women in the Weinstein case. And the judge also let him testify about paying off Trump's doorman, who, though he wasn't saying that he'd had sex with Trump, he was telling the story that Trump had fathered an illegitimate child. Well, none of that has a damn thing to do with anything going on in the Trump case.
Right. And is that the same? That's the same court, right? Like, I mean, Judge Merchan would be bound by the same.
Yeah.
Okay. Yeah.
Yes, he is the trial court. Merchan is the Court of Appeals. And, they've got an odd naming system. The trial court in New York is called the Supreme Court, and the top court is called the Court of Appeals, and there's an intermediate court. It's called something else. So
New York, I think New York does a lot of weird things. I thought it was so weird that the defense did closing arguments first. That was weird to me.
Yeah, and it was a big handicap to the defense in this particular case because they didn't know what the hell the prosecution was going to say until they were finished and couldn't rebut it.
Yeah.
There's a third illegitimate piece of evidence that should have been excluded under Rule 403, and that was the salacious details of Stormy's encounter with Trump. What he was wearing, what his cologne was like, what he said, what she said, that she blacked out, that he was powerful and she wasn't. All of that has nothing but unfair prejudicial effect. It is probative of nothing. So her sex story should not have been admitted. All they needed was, did she threaten to tell a sex story? Yeah. Was she paid to shut up? Yeah. And then try to prove that's a crime.
So, I think I heard you in a previous interview say that Trump's lawyers should have moved to dismiss when that conviction was tossed, based on citing Weinstein. Is it too late?
I didn't say that.
Oh, okay.
What I did say was that when Weinstein's case was reversed on grounds that I thought tracked the error that Merchan had made in the Trump case, I expected Trump's lawyers to file a motion for mistrial, not a motion to dismiss.
Okay.
A motion for mistrial would just have stopped the case, sent it back to square one to be tried again.
Okay. But they can still file, use this on appeal, correct? Cite the Weinstein reversal?
Yes.
Okay.
Yes.
And then you mentioned the plea, Michael Cohen's plea being discussed. Is it common for another person's either plea or conviction to be used in, I guess, non-conspiracy type cases? So, he wasn't charged with conspiracy, right? So, in that type of situation to be used to, I guess, impugn guilt on another defendant. Do you get what I'm saying?
I do. I am not a criminal defense lawyer, but I have read a little about it, and I am absolutely convinced that you cannot introduce the plea of one person to imply or argue the guilt of another. Now, there are circumstances when such a plea can come in, but this was not such a circumstance. The circumstance when that plea could come in is if Trump wanted to use the plea to attack the credibility of Cohen by saying, you are a convicted felon. You pled guilty to crimes, didn't you? But this was offered by the prosecution, which was vouching for the credibility of Cohen, and the prosecution had no damn business at all putting in a plea of guilty to attack the credibility of their own witness.
Right.
Now the judge did, in the jury charge, include an instruction that says you can't conclude that Trump was guilty based on Cohen's guilty plea. But by then the damage had been done.
Right.
The skunk had been in the jury box. The stench was still there. That instruction came way too late and was ineffectual.
Thanks for tuning in to the latest episode of Court Watch. My next episode will break down major rulings from the Supreme Court that we expect by the end of June as the justices wrap up this term. If you have not subscribed yet to this podcast, please do so, and also feel free to email me interesting questions or topics that you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.